Your Honour, my name is Dwyer, D-W-Y-E-R, initials MC, and I appear on behalf of my client Simon. Today I make submissions according to Section 130 of the Queensland Evidence Act to enliven the court's discretion to exclude the evidence of my client's recorded interview on the basis of public policy and based on the conduct of the police officers who arrested Simon and their disregard of the Police Powers and Responsibilities Act. It's important to note that for the purposes of the relevant legislation that Simon is considered to be a child according to Schedule 4 of the Youth Justice Act, as he is not yet 17. To apply this discretion, the factors according to Bunnings against Cross, as affirmed in Queensland by Hasler, must be considered. The relevant considerations as to whether the evidence was obtained unlawfully are whether the police deliberately disregarded the law, whether the illegality results in the evidence obtained being unreliable, whether there were pressed circumstances, the nature of the offence, and how the legislation tries to restrict actions. Firstly, Section 403 states a police officer can arrest a person for questioning of an offence if they reasonably suspect the person has committed it. This detention period cannot exceed more than 8 hours. My client was arrested at 10 a.m. without charge and was formally charged at 7:05 p.m. This means that he was unlawfully detained for 1 hour and 5 minutes. Nothing on the facts suggests that an extension was applied or granted. Moreover, Section 365(3) of the PPRA states it is lawful for a police officer to arrest a child without a warrant if they reasonably suspect the child has committed an indictable offence. However, according to Schedule 1 of the Youth Justice Act, a child should only be detained in custody as a last resort and for the least justifiable time in the circumstances. My client was arrested and put in the back of a police car for 3 hours and was then driven 45 minutes to the nearest police station. This meant that it was almost 4 hours until Simon was actually questioned of the offence. It cannot be argued that this is a justifiable amount of time to have detained my client. Furthermore, Section 420 states a police officer must inform an Indigenous person that a representative of legal aid will be contacted on their behalf and then, as soon as reasonably practicable, actually attempt to notify the legal aid organisation. This section is only mitigated if, having regard to the person's level of education and understanding, the police officer reasonably suspects they're not at a disadvantage compared to other members of the Australian community. Simon was told that legal aid would be contacted on his behalf, but there's no record that that conversation ever occurred. More information is required as to Simon's character and reception of the police officers. However, it would be ridiculous to argue that Simon's behaviour was so mature, functional and intellectual that he behaved in such a way that the police reasonably suspected that he was not at a disadvantage. Not only is Simon a child, but he is from a small community of mostly Indigenous people in Cape York and was likely suffering from a significant cultural barrier. His disadvantage is exemplified by the fact that he somehow pleaded guilty to an offence that he didn't commit, and obviously the police suspected that he needed legal aid as they told him that they would contact them. Upon an accumulative look at the police officers' conduct, they have repeatedly and deliberately not followed the PPRA and acted unlawfully. As a result of the conduct of the police officers, the recorded interview where Simon confesses to the murder is completely unreliable. The stress and strain of the situation that Simon would have been experiencing, alongside the repeated mistreatment by the police officers, completely impacts his reliability and nullifies and invalidates his interview. Similarly, there is nothing on the facts to suggest that the police behaviour could be justified according to the circumstances. There is no evidence that the police were unable to transport Simon at an earlier time, nor is there any evidence that he waived his right to legal aid. Although I do understand that the offence was of a serious nature, these are basic principles that needed to be followed, and it cannot be mitigated by the gravity of the offence. The legislative material that the police officers have breached is specifically designed to restrict and regulate police powers according to Section 5 of the PPRA. To allow the evidence to be admitted in light of this, and the fact that the police officers were disregarding their very own legislation, would be completely inappropriate. Your Honour, we cannot encourage police officers to flagrantly flaunt the rules that govern them by assuring them that no matter their actions, the evidence they gather will be admitted. Police officers are required by law on a regular basis to enforce these principles that they have breached. Either the police were aware of their duties and deliberately disregarded them and acted unlawfully, or they are admitting such a level of incompetence that it would be inappropriate for them to continue as police officers. As a result of the police officers' unlawful conduct, they have acquired a false record of interview that is incriminating to my client. The evidence should not be admitted in the interest of public policy, as the police officers acted contrary to their own legislative provisions, but also to the standards of the Australian community on the treatment of children and adults in custody. As Justice Stephen and Aiken stated in Bunnings, it is not fair play that is called into question in such cases, but rather society's right to insist that those who enforce the law themselves respect it.